White House declined to comment on reports suggesting the presence of U.S.-made landmines in Iran. Press Secretary Leavitt refused to confirm or deny the use of American landmines, citing no comment on the matter. This asked about the origin of the landmine reports and whether President Trump had signed off on their use. Leavitt responded, "I don't have any comment on that report today." When pressed further about the use of landmines in Iran, Leavitt again declined to comment, saying, "I don't have any comment on that." The U.S. government's cautious approach to commenting on military actions and equipment use in sensitive international situations is highlighted by this refusal to comment. The lack of official confirmation leaves the nature and origin of the reports unresolved. With the White House remaining silent, the status and implications of these reports remain unclear, potentially impacting diplomatic relations if the claims are substantiated. The New York Times is accusing the Pentagon of defying a court order to restore press access rights to its headquarters. U.S. District Judge Paul Friedman ruled in March that the Pentagon's new press credentialing policy violated journalists' constitutional rights, ordering the Pentagon to reinstate credentials for 7 times reporters and stressing that his decision applies to all regulated parties. However, the Times claims the Pentagon has since implemented a revised policy that circumvents the judge's ruling. The revised policy, according to Times attorney Theodore Boutros, imposes radical new restrictions on journalists. This makes it harder for them to do their work. Government attorneys argue that the Pentagon's policy fully complies with the judge's directives, stating that the policy includes safe harbors protecting routine forms of news gathering. The legal battle stems from a December lawsuit filed by the Times against the Pentagon over a new press credentialing policy that required reporters to sign non-disclosure agreements and limit their access to the building. The policy sparked a walkout by reporters from mainstream news outlets in October. The Times asserts that the revised policy is an attempt to bypass the judge's ruling and further restrict press access. With the case pending before Judge Paul Friedman, the implications of this legal conflict highlight the constitutional and procedural issues around free press access to government operations, particularly in matters of national security. Former South Carolina Governor and Congressman Mark Sanford filed candidacy paperwork just before the March 30th filing deadline to run in the June 9th GOP primary for South Carolina's 1st District seat. Sanford's political career has been marked by both success and controversy. He previously served 6 years in the 1st District seat before his gubernatorial run, which ended in 2009 after a personal scandal led to his resignation. This recent filing comes on the heels of Sanford's unsuccessful 2020 presidential bid and his loss of his House seat in 2018. The 1st District seat is currently held by Nancy Mace, who is running for governor this year. Sanford's campaign messaging focuses on addressing the national debt, a theme that has defined his political stance throughout his career. His candidacy highlights his continued efforts to return to political prominence despite past setbacks. The Supreme Court is set to hear arguments on Wednesday regarding the constitutionality of President Donald Trump's executive order. This seeks to restrict birthright citizenship for children born to individuals in the U.S. illegally or temporarily. The order, signed in January 2025, faces significant legal challenges, with every lower court ruling against it. Legal scholars and immigration advocates argue that the order violates the 14th Amendment's Citizenship Clause. This case centers on the interpretation of the 14th Amendment, which grants citizenship to anyone born on U.S. soil, subject to the jurisdiction of the United States. The order would impact over 250,000 babies born in the U.S. each year, according to research from the Migration Policy Institute and Pennsylvania State University's Population Research Institute. The hearing marks a critical moment in the broader debate over immigration policy and constitutional protections. Solicitor General D. John Sauer will argue for the Trump administration, while Cecilia Wang from the ACLU challenges the order's legality, asserting it redefines the long-standing interpretation of American citizenship. The outcome of this case could set a significant precedent for future immigration policy and the interpretation of constitutional rights, shaping the legal landscape for years to come.